Okay, so welcome everybody at the Huygens Institute and welcome everybody from around the world watching this streaming video presentation. We'll have 4 speakers today from the Huygens Institute, and I just wanted to introduce as the organizer the Huygens Institute itself, which is located in The Hague, the Netherlands, and is part of the Royal Academy here in the Netherlands, and studies both history and literature from ancient times until now. When we were very glad to receive the invitation to join this conference, but we also realized that we are not particularly well fit to talk on the very theme of the conference, but we chose, we asked, and we got approval that we might deliver some historical background to the theme of privacy and surveillance in the digital age. All of our speakers will sort of tie to the theme, but give you some considerations and some thoughts on topics that relate to the theme in a historical manner. So I would like, without further ado, just quickly show you the titles and the names of the presenters. And we also want to show you the hashtag that you will need to address questions to our speakers. And please also include the @HuygensING address tweet account so that we will receive the questions and we'll relay these questions for you to our speakers. All of our speakers will have exactly 12 minutes to deliver their presentations, which is fairly short, and we'll have 3 minutes of local answers and questions and answers. Any questions from the broader audience we kindly direct to the Twitter stream where they will be answered in due time. Thank you very much and enjoy our presentation.
Okay. Welcome, colleagues and colleagues around the world. Today I'm going to talk about a topic which is only in a tangential manner related to the overall theme of this Around the World conference, Privacy and Surveillance in the Digital Age. My theme will be open access publishing in humanities and social sciences and the issue of ownership of academic publications. Academic publishing has become a topic of hot debates over the last decades. I think it's safe to say that this is due to developments which are intrinsically connected. The first one being a technological one. The World Wide Web and the rapid development of online publishing of academic publications of all sorts, starting with working papers, soon followed by online journals, and more recently the online publications of books, both monographs and edited volumes. And next to these digital versions of all the analog forms of publications, a variety of new forms of publications have been developed on the web, such as video, databases, animated graphs, and now even including a variety of social media such as Twitter. The second development which had led to much debate is the rise of open access as a movement and even as an ideology and as a publication model and business model. I'll start with the definition, a simple one by Peter Suber. Open access is academic literature which is digital, online, free of charge, and free of most copyright and licensing restrictions. To quote Jonathan Bate in a recent article in the Times Literary Supplement, the open access movement has been gathering force as an inevitable consequence of the global dominance of the internet. So I won't go into the origins and development of the open access movement as such because of time limits, but it's generally accepted that the origins of the movement are to be found in what is labeled a serials crisis. Steeply rising prices of subscriptions to academic journals, in combination with stagnant or even shrinking library budgets, led to a situation where libraries were less and less able to pay for and therefore provide access to an ever-growing number of academic journals. It's also important to qualify here that much of these steep rises in subscription prices and the serials crisis were, initially at least, predominantly happening in the sciences, and far less in humanities and social sciences, where prices still are on average considerably lower. Some have even argued that open access was an answer to a problem created by the sciences, or at least by important stakeholders in the sciences, the large commercial academic publishers, but now has been imposed upon the humanities and social scientists and confronting them with structures, models and conventions that do not necessarily match their own publication cultures. It has been argued from various sides, and lately especially within the academic world in the UK, that academic publishing is too broad a term to acknowledge the huge differences in the relation between research and publishing when one looks at the sciences at the one hand and the humanities and social sciences at the other. This disciplinary divide is lately becoming acknowledged more widely. For example, in the UK, I can refer to recent publications by the British Academy for the Humanities and Social Sciences that debate and explore the state of affairs and the various often widely diverging opinions around open access publishing. So in this short presentation, I want to focus on two aspects of academic publishing to see how they differ in humanities and social sciences compared to the sciences, and insofar relevant, how these differences may relate to the recent debate on open access publishing and the question of ownership of publications. The first aspect I want to look into is authorship, and the second one is editing and publishing. And I think from these two aspects we can broaden the discussion to a more political theme, which I could label as democracy and publishing. This final theme can be captured in three questions. Should academic publications be considered as public goods, or should they be considered as commodities? Another question would be, for whom are we publishing? So this is a question about readership and the societal impact of academic research in humanities and social sciences. And then finally, I want to wrap this up in the question of ownership of academic publications. So first to the differences between humanities, social sciences and sciences in the aspect of authorships. Multiple authorship in sciences versus individual scholarship of authorship in humanities and social sciences. That is a first big difference. In sciences you have the kind of publications which will feature up to 10, even 50 authors, where in humanities the individual author is still predominant. But not only the number of authors whose names appear with a scholarly article differ, but also the way in which writing is often seen as a more essential element of the process of doing research in humanities compared to sciences is a big difference. For instance, the idea that in humanities the development of a long argument is essential to academic research, or an essential element of academic research, is a huge difference. Also, in terms of the form of publications, there are huge differences. In sciences, almost 100% of all publications appear as journal articles. In social sciences, this is about 65%, whereas in, for instance, history, it's about 35% in articles, the rest in monographs and edited volumes. These figures are from a report about the situation in the UK, but it's generally thought that this is more or less the same all over the world. One of the consequences of these differences in the form of publications is that as a result of this serials crisis and the problems in academic publishing, there's now also the idea that also the monograph is becoming more and more in crisis. So the second aspect I want to look at is editing and publishing. If there's a different relation between research and writing and publishing in humanities and social sciences as there is in sciences, then it's likely there's also a different role for editing and publishing. And this leads to different publishing cultures and a different, what now commonly called, publishing ecosystem. If we look at the development of open access publishing, you see that in sciences the article processing costs or authors' fees have become dominant, while in humanities this is often seen as unethical, leading to perverse incentives, because the more you publish as an article, as a publisher, the more article processing costs can be charged. But also because in humanities, scholars have the idea that they actually do most of the work in the actual editing and publishing. They are requested to deliver very clean copy to the publisher, and are also the people who do the whole peer reviewing process. So what is then the value added by publishers? Then there is also an impact on, as I said before, the form of publication. Because the dominant model for open access publishing at the moment is where the costs involved in publishing are covered by the article processing fees, or the problem arises, how about books? Because then the costs for one publication rise considerably. At the moment, different alternative business models are being developed to find a future for monograph and edited volume publication in open access. Examples are Knowledge Unlatched project, Open Edition, and Open Book Publishing. So, where does this lead? How does this lead to the issue of democracy and publishing? And the question: is an academic publication a public good or a commodity? The essence of the toll access model for publication, the traditional publication model, is based upon the exploitation of intellectual property. But the open access movement starts from the principle that all publications should be freely available. My conclusion is that ownership in terms of copyright and licensing is closely connected to all these issues, as it determines who can control the access to works published. The traditional so-called toll access model is based upon the commercial exploitation of intellectual property, hinging upon the author handing over the copyright to publishers, who then in return limits the access to the publication by putting a price to the access in the form of paid subscription or a price to a book. As this system now seems to have reached its limits as a result of the development of the digital online publishing, it's important that humanities and social science scholars become aware of the crucial role of ownership in scholarly publications, and start to learn more about the issues of licensing and the pros and cons, for instance, of the Creative Commons licenses, and enter the debate about the future of academic publishing more actively. Thank you. moeten vragen.
Ja, dat is inderdaad even blijven staan. Ja. Willen we de vragen meteen achteraan?
Ja, ik kan
Ja.
ik laat het gewoon.
Oh, je laat het gewoon lopen? Oké.
Ja.
Deze. Oh nee, je hoort hem niet, hè? Dus
Welcome, everybody. I want to tell you something about uncertainty about authorship, since that also has to do with privacy issues, of course. I will give 3 examples of authorship uncertainty. One is deliberately created by the real author. The other is based on doubts on the genesis of a text. And the third one is created, in fact, by gossip. And in this digital age, we have new methods of looking into authorship uncertainties, and that will change the way authors perhaps are writing as well. So that's why I thought this would be an interesting topic for this conference. I'll give examples from different time periods from Dutch literary history, from contemporary times, from the Middle Ages, and from the end of the 18th century. So I'll start with the first example, which is contemporary. So authorship uncertainty was in fact deliberately created by the author, who published a novel, De geschiedenis van mijn kaalheid, under the name Marek van der Jacht. It's translated, by the way, into English under the title The Story of My Boldness. This novel got a prize, a literary prize, for best first novel. But then some readers thought, well, this is remarkably much like Arnon Grunberg, an already published author. He had already published 4 novels, and he already got the same prize 6 years earlier. So then some people started to find a way to check who would be the probable author of this novel. And they used a new method from Digital Humanities, the zip method, using a compression technique to compare the novel with several parts of novels of other authors. And then the researchers thought they could be quite sure that Arnon Grunberg must have been the real author. And when that got published in the press, Grunberg said, yes, I did it. So he admitted guilt, you could say. So that's a quite interesting a thing happening based on the use of new techniques. Back to the Middle Ages, the second example of authorship uncertainty, which in fact could be said to have arisen from uncertainties about the genesis of a text. In the Middle Ages, of course, texts were copied manually. Each scribe could add or remove stuff from the text, could change the text. So you never know what you are looking at when you look at a medieval text. Is this how the author meant it, or has some scribe interfered with it, creating a new text, a different text? So the example I want to give is a medieval Dutch Arthurian romance called The Romance of Gawain, the Roman van Walewijn in Dutch. It was written about 1260, we think, but we have only one complete manuscript, which has been dated around 1350. So that's quite some time later than when it was probably written. It has quite a lot of rhyming lines, almost 11,200. There were 2 authors, which is stated in the text. At the end of the text it says that Penning started the novel, and that Vostaert, but that he didn't finish it, but that Vostaert added about 3,300 lines to the text. So about 3,300 lines. We're not sure exactly. This person mentioning this was not sure exactly how many lines. Scholars have been trying to find out at which line exactly the second author took over from the first. And they do not agree on this. And there's quite a big difference between some of the scholars. Most of them say it's around line 7,800 and something. But there's one who says, no, this 3,300 lines is a mistake, is a scribal error. It should say 300 lines. So the second author only added the last 300 lines. We thought that we could use modern authorship attribution methods to check where the change exactly took place. There were also 2 scribes in this medieval manuscript. So one wrote the first 6,000 lines and the other the rest of the text. We used what's called the Burroughs delta procedure. I won't go into that very much today, but it the core of it is that you look at the frequencies of the most frequent words in the text, and that you use a whole corpus to compare all the frequencies with the text of which you don't know the author, and that the text that ends up closest in use of frequencies of words to the one you don't know the author of probably has the same author as the disputed text. But we had only one text and not a whole corpus. So we decided to divide our text in different texts by walking through the text, so-called rolling windows, you could say. And you should think of this something like the computer walking through the text, taking one line as a step each time, and this is the way we would expect something happening in the graph resulting from measurements on the text. So we would expect something like first author, a big dip, second author. That was our hypothesis for our analysis of the text. We looked at the 150 most frequent words, and in the first 50, so the 50 most frequent words, such as the, and, in, or, that kind of words, there was a big peak in the graph around line 600. And I just mentioned that's the change of the scribes. So not the area in which the author changed. So we, my colleague Joris van Zunert and I, who is chairing this session, really found something very interesting about what freedom medieval scribes took with their texts. They are changing things in the higher frequency words, function words you could say. When we looked at the lower ranking, 100 to 150, this is what would rather fit our hypothesis. So here we do see that there are two authors in this text, but we still don't see an exact line where the one took over from the other. If you look at the in-between section from 50 to 100, the ranking on the frequency list, we see author 1, we see author 2, but we also see something in between, which is a plateau you could see of about 400 lines. And that set us thinking that maybe we've been thinking the wrong way all the time. There is not one line, but isn't it much more logical that there's an area in the text in which the second author went back to a couple of hundred of lines to change what was written by the first author, who perhaps didn't finish it, who didn't finalize it according to his taste. So based on this approach, we are now looking in a different way to combined authorship. Third example, created by gossip. I hope you'll be most interested by the gossipy part of this. It's taking place at the end of the 18th century. There were two women writers, Elizabeth Woolf and Agatha Dakin, who collaborated on several epistolary novels together. And they were very good friends. They even lived together, and they wrote several epistolary novels. And Elizabeth has become famous. She is seen as the lively one, the sharp-witted woman who must have been the really smart of the two. And the other one, Agatha Dakin, is supposed to be rather boring, simple, in the shadows of Elizabeth. And that's sort of the idea that's been living since their own time. And they even stated that themselves, that people around them told them that they thought that Elizabeth must have written all of this, and perhaps Agatha was only a secretary, and that they were very annoyed by that themselves. And in one of her publications, Agatha Dakin wrote about this, that this is a very good sign that these people stating this don't know anything about Elizabeth and Agatha, that they're totally misinterpreting their natures. And if she would find the time, she would draw up a list in which she would indicate these are the fictional letters that I wrote for our epistolary novels. Unluckily, she didn't get around to that, and so I thought, well, maybe we can use the new digital methods to find out if this is correct, if we can make sure that the gossip is not true. So we used multivariate analysis again, but now based on the Stylo package that has been written by Maciej Eder, Jan Rybicki and Mike Kestemont, which looks at principal component analysis, cluster analysis, and also bootstrap consensus trees. And I will give you some examples in the last 2 minutes that I have for this talk. The first one is to show you that indeed authors are recognized. I compared 3 of the epistolary novels of Woolf and Dakin with 3 other novels from the same time period, also epistolary novels. And if you look at the 10 most frequent words and do a cluster analysis on that, you see that the 3 works by Woolf and Dakin nicely cluster together and are separate from the 3 other novels written by other authors. So that's sort of the first proof that indeed our methods can distinguish between authors. But can we distinguish between Woolf and Dakin? One of the suggestions of the gossipers was that Elizabeth took care of the nice and the witty persons, the letters of the witty letter writers in their novels, and that Agatha took care of the boring ones and the religiously fanatics that are also in the stories. So we decided to make different text corpora for each of the characters, and we compared the 15 longest letter writers with each other using these same tools. And then we found that almost all the characters look quite alike as to style, that there was only a couple of characters that were diverging from the rest. They are leaving the cluster at the left-hand side, you could say. So our conclusion, in fact, is that probably they did not divide work according to letter writers, or they switched working on the same texts all the time, rewriting what each other did. So that's very difficult to test. The other one is that their style of writing is so much alike that they can't be told apart. But anyhow, that sort of proves that they did collaborate very closely on these texts, and that it's difficult to distinguish between them. We could also test that by looking at their private correspondence from the same time period. So that led to another graph, and it's a bit difficult to see, so I'll explain what I think that we can see, namely that the forewords and the afterwords of the texts they wrote together, which was undersigned by Elizabeth, is indeed most probably by her, based on her private letters. And on the other side, that their letters are also very much alike, even when they write them to other persons. So to sum up about this last case, the 2 authors cannot clearly be distinguished, so I think it's very plausible that they did collaborate just as they told us in their own texts. And there's no reason to believe the gossip that Dakin was very much inferior to Woolf. And in this case, I would say trust the author. To conclude my talk, what can we say about authorship in the digital age? Well, by having new methods to find out who the real author of a text is, I think things could change in how authors write. We can apply that not only for contemporary texts and forcing authors to admit that they have been writing under an alias, but we can also use it to look at the past and try to solve authorship problems from the past. All of this opens certainly very much new opportunities in research directions in the digital humanities. Thank you. Are there any questions?
Thank you, Karine, first of all, for a very interesting talk. Indeed, any questions from the audience? Roelof.
Oh, yeah.
Just stand up so that the audience can actually see.
It's Karine, I was just wondering about the medieval text, because we have authors and copyists. You know now the 2 authors from Malewijn, but is there also, I couldn't quite grasp it in the quickness of the presentation, but there's also a distinction between copyists itself. I mean, copyists can also alter texts, and then you have, well, 2 answers to one question you might have. Can you comment on that?
In fact, what we found is that by looking at the different ranking in the frequency list of words, we could see where copyists were most active and where authors are least interfered with. So the more frequent a word is, the easier it was for a scribe to change it. So it's easy to leave out a particle, an article, or a conjunction, but it's much more difficult to change a noun, to change content words. And I think we have given the start to new research about not only scribes in medieval texts, but also editors in modern texts. I think it's about comparable, that they could do the same thing as a scribe did in the past.
I can't resist the opportunity to ask you a question myself. I don't know how much you studied the Grunberg case, but I wonder if you know if he or if you know of other examples in Dutch literature where authors start playing with the boundaries between fiction and their real life. I think Grunberg, if I remember correctly, was trying to not so much write a novel under a pseudonym, but he was trying to deliberately kind of diffuse these boundaries between what is actually literature, what is real life, what is the life of the author, in fact what his privacy is and how much his own literature can invade that kind of privacy. Do you know of any examples where authors start playing with that in history? Or?
Yes, there are some other examples. One of them is a novel by Atte Jongstra, The Life of Henry Fix. Right. He makes use of historical documents and presents his novel as sort of a historical ego document. And that gave rise to discussions in the press as well about plagiarism, for instance, right, and other kinds of things. So there are examples like this, but most authors writing under an alias reveal that pretty early.
Okay, thank you. Maybe time for one quick question. Peter.
I was wondering, I happen to be studying a novel which was published first on an internet forum by an author writing under, let's say, false pretenses, pretending to be a girl in trouble and asking for help. Of course, in usual situations, people are using internet forums to discuss their problems, and anonymity is an important aspect of those forums and really a condition for these forums to be able to function. Do you think the techniques you are discussing are in any way a threat? Are they that effective that people should be afraid that their questions, that their identity can be decided based on the questions they ask on those forums?
It's a very good question. I think that depends on how long the texts are that they write. Because for this kind of analysis, if you want to be sure about the results, you need a large sample of texts. Ideal would be 5,000 words. And I think on many of the internet forums, messages are much shorter. So I don't think they have to be afraid yet, because we haven't solved that problem.
Okay, thank you once again, Carina. And another big hand to Carina for her presentation. And we'll continue to our next presenter, Roelof Hol. Please take a stand.
Ladies and gentlemen, welcome to this short presentation on the privacy for this online conference of KIAS. My presentation is called Quis Custodiet Custodientes? Who guards the guardians? Since it's a very broad concept, privacy in the field of historical records and the use and the research on them, I have made only a few slight observations coming from the public access of records to the right of privacy, and in the end I will have some remarks on the right to forget. My background is an archivist. I'm a state archivist at the National Archives, and since a few months I work as a liaison at the Huygens International Institute for Dutch History. My presentation is going in two parts: some observations since the 18th century on what is privacy, or what is the relation with it with public access, and the second is privacy and the right to forget. If we look at privacy in historic perspective, we can say that it started, although people did not mention it in that way, in the late Middle Ages, when people start talking about defending your personal rights towards the government, not the king. The king was an absolute, from God-given thing, you could say, but things like the Magna Carta, English common law, were all kinds of where rights of the people were more defended or lesser defended. And those rights were about your personal home, your family, your house and goods, life and limbs, etc. You could not be arrested without a warrant, etc., etc. So you could say in all it were vertical rights. It was the government, barons and all what belongs to it, the court, you could say, legal system, that came down on the citizens and the population. And so the rights were a legal defense against abuse, etc. It was not privacy in the modern statements where it is not only vertical, from the government top down to the population, and horizontal. What do I may know about you? In the 18th century, I make large steps into the time. In the 18th century, we, of course, had the opening of government records. People start asking questions. The Enlightenment came. People wanted to know more things about everything, you could say. And I have taken two examples. In Sweden, there was already an ongoing battle between the Riksdag, the parliament, since 1716, against the court, the king of Sweden. And what ended after a long debate, etc., political unrest in 1766 with the freedom of press, which meant that press could be printed and you could, well, freedom of speech, etc., etc. And also in that period, people was given the right to consult public records, records from the government, not your personal document, but records from the government. Well, as we know, in the end of the 18th century, we had the French Revolution, and then also in avoidance of people that rights were not manipulated by the government, people got public access. It's the first time that really public access to government records was given into law, and that all the laws should be kept in an open and public space so that people could consult them and say, this is the rights where I'm entitled to and can do. And so the first archive law in the world, you might say, is the French law of 1790, later on renewed in 1829. But still, considering the topic of this presentation, it was individual privacy was not yet a legal concept. Public access of all the people to government records was the first priority, not the protection of your own privacy. But the first time that we see something changing is in the end of the, you could say, the 19th century, in the early 20th century, when the new media is coming in, photography, and the press is growing, especially yellow press, who wanted to know more about private lives of citizens, or making photographs. You didn't know that you were photographed when you came down the stairs, although at that time making a photograph was a fairly large things and things, but at least people could take your photograph without you giving permission to do that. So you see that access now, access to records, access to news, to things which are people saying about you, is bringing the concept of privacy into the public domain. And we see then in one of the most famous journals of that time, Harvard Law Review, in 1880, the first time the right to privacy being defined by, well, in this case, law people who were defining this thing. In the Netherlands, we were not that quick. We were still working our way to the French, you could say, the French concepts of public access to government records, which we defined in our first archive law of 1980. And we were defining the public access, of course, and also the supervision of governmental records. But access was the message, not privacy. If we look, and I'll just take big steps again, in the 20th century, it goes ups and down. There are legal suits about privacy issues, etc. If we look at the privacy in the Netherlands, when became it a public discussion was in the 70s when we had the census. People start asking questions, why does the government want to know all those data about my life? Who was my father, etc., etc. What am I earning, things like that. So people were starting questions, giving resistance. There were a lot of people who refused to accept the civil servants who were coming on your door and doing, well, these large interviews, etc. And we got legal actions, and then we had several law by the Parliament, the Privacy Law of 1979. But very important to know that there was a concept of privacy. People should be protected against it, and you were allowed to, but it was not defined as a constitutional right. It's not in our constitution which say privacy is your constitutional right, because if you do that, well, then they have a lot of legal issues about it. I will not go to in that detail. And especially, that was in the 70s, we were taking out of the government forms all kind of nominations of personal information like gender, religion. I mean, all the lists, if you see in government records or in public records in the first half of the 20th century, all contains who, what kind of religion. If you see emigrant papers from the Dutch administration to the Australian administration, it's in there, what is your denomination. You can still use that now as an historian, but it's not legal anymore to take it down as a government. And of course, political opinion, union activity, all those, right. Now, in the last part of the 20th century, before we went into the 21st century, we saw another, you could say, innovation in media landscape, which is, of course, the internet and the social media. And we also saw at the same time a growing uneasiness on privacy issues. What is everything on the internet, which is about me, etc., etc. When your neighbor asks you questions about what in my case happens, about something I said in a meeting, which was a public meeting, so it didn't matter, but it was a public meeting, 10 years ago, because he found it by Googling my name, he found that what I had said in this particular meeting on private archives, I was a little bit surprised that it was still on the internet. I never knew it was on the internet, that somebody put it there. But at the same time, people are also become aware that internet is safety first, 9/11, things like that. It gives you an enormous, it also gives you, it might give you a safe feeling if we amass data on all kinds of activity. That's why if you travel to America, my eyes are about 20 times somewhere in an American database, because each time I had to look into those things at the airport. So there is a unbalance, you might say, between privacy, individual privacy, and what governments, or what we all also feel as a population, it should be safe. So we have the criminal fringes in the domain of sexual harassment, identity theft, pedophile, etc., etc. We know all the ugly things which also can happen, all because of data that are massing on. Is there any protection from the government? Well, we do have in the Netherlands, we have the College of National Council on Privacy Protection, but in fact it is the power of that institution is, well, not that big as one should consider. So my summary here is that privacy still is a vulnerable, volatile concept. It changes depending on the time and the context of time, and it's a political issue all the time. So if we look at the question, who is guardian, as I start my presentation, who and what, we have different questions we might answer of just giving a few things. The second is interesting. Question is, what are personal data? example, if we can now change your, if you are shopping, we can, through Wi-Fi, we can see what are you going to shop, what are you doing in this shop. We can exactly put it down, and it's legal. We can do that. So we can say the next time, if you come at the cashier and you have change, you can say, oh, well, the sugar is, your brand of sugar has arrived. We can do that. It's a legal thing to do. There's no one legal thing against it. But the thing is, do we want it? That's more important, of course. So the conclusion of my presentation is not only who guards the guardians, but also who are the guards. Is it you? But is it me? Or some professional, politicians, search engines, or just an ordinary civilian? You still don't have the answers here. But what will happen in the near future? As this is a cartoon from NRC May 15th, so last week, very quick. And it's about the right to forget. We have, I will skip out a little bit of this thing. There's a fresh verdict of the European Court of Justice, May 13, which states that in Europe, in the European Union, you have the right to be forgotten. So that information on your person, which is being kept in a public accessible record, a newspaper, doesn't matter what, that you can ask the search engine to cut the link between your question, do you have anything on me, and that particular newspaper. It was this, in this case, was a Spanish merchant who had been broke, and it was being published in the paper, and due to the search engine, you could find 20 years after date that he had been almost broke in 1998 or 1992 or something like that. And he asked to Google, cut this line. And Google refused because they said, this is what we have done in America, not in the European Union. So it became a legal battle in that way, things like that. But the thing is that we have now two parties in Europe, you could say. The one says, online selection of links is contra the freedom of expression. And the other say, it is, if you do that, abuse is possible if you cut links. Because a hotel where you have bad reviews, the hotel owner asked Google, cut the links with the bad, because it's not true. And then what Google has to do, research again, go to the hotel, sleep there and things like that. Well, this is not going to happen. It will also be, of course, very expensive. So you see, privacy, I haven't read the verdict yet and all the comments, but I think that the power of the search engines in the near future will either be going down, which is not very nice for research communities, because we will lose connections which we did have or which we might have if you were allowed to do it. So there is always a balance between what are we able to do, but if you can't trust the search engine for your research, well, you might have a problem there. So, end of this presentation. Any questions?
Thank you, Rudolf, for a very interesting and a very timely presentation, I think. Indeed, any questions from the audience?
I have a comment on...
Gertjan.
Okay, yeah. I have a comment on the last part, on the right to forget. I've been following this case very closely. And I would like to hear your thoughts on this, because the court ruling basically said that the links from the search engine had to be cut to the original data. Court ruling did not say remove the original data.
No.
So with this court ruling, you're basically saying, okay, you're not allowed to search for it, or you're not allowed to index it. You are allowed to search for it. If you manually search for it, you can still find it. So what is the effect on of this court ruling in that sense on privacy? But because the data is still out there.
Yeah, well, the thing is that you give, it has also a part in the large, this present ongoing discussion about small data and big data. And if you have amassed a lot of big data, with all kinds of, which are done by link, usable by linking other data to this particular question, if you start cutting their corners, then you might have a problem seen from the researcher. In the privacy, in the field of the privacy, you're quite right, there is no removal of original documents or newspapers, so you still can search all the newspapers in the world and you will still find this mention on being his broke. But the thing is that as researchers we used the search engines to say, well, we can do this in a better way to research, we can do more research because we have quicker access to certain data. So there is a distinction between there. If you, I just try to compare in the analog society where we had a discussion years ago from the archives when people said if a child is 18 years of age, his file with the guardian authority should be removed, expunged, completely destroyed, because you will not hinder a person with the fact that between 12 and 18 he was part of a program, you could say, in this country which we use when your parents can't cope with you, etc., etc. So a huge outcry came from research communities that, well, this is removing the exact material in which we can find information on how is the society coping with that kind of problem. So in the end of a long discussions, etc., I was one of the archivist committee on that, and we decided on preserving the files ending on 0 and 9, random selection, and make all the names, reference, anonym. So that it's now, you have these files now, it's a selection. Yes, it is a selection. But that was the only thing, because the legal system said it should be out. We don't want any reference after 18 years to a child that he was part of a guardianship program. So it is not a very clear thing to say this is right in the privacy or not. We have search engines. We want to use them for all kinds of reasons. We want to predict how far is the flu analysis coming. We have a lot data on flu, and we like to predict what country is the flu early, etc., etc. If we are going to cut their corners, well, we can't. Besides the whole big data thing in itself, but that is too much for this short presentation.
Can I ask one follow-up question?
Yeah, if it's a quick one.
Yeah, sure. Because then I would like to know how the ruling affects writing as a researcher your own web crawler, because you don't have to depend on Google to index the data. You can basically write your own crawler and index the data yourself. So in that sense, I don't think that as a researcher you're going to lose your access to this data.
No, but the thing is that the moment you place your crawler and all the data behind it on the internet, it's there. And it's accessible for everybody. That doesn't matter who is the author of. That's what the court as well said. He said, because the lawyers of Google said, this is being done in America. It doesn't affect Europe, which is of course nonsense, because internet is not American or Europe or whatever country, it's just the world. So it doesn't matter where you make it, it gives a connection, and we don't want to have that connection. At least we do not have it, because that the European Court can only say about using Europe, of course. But that affects us all, of course. So
Okay, thank you, Rudolf. I think that's a very nice note to end this presentation on, and in fact that wraps up our contribution to this Keys Around the World conference. And I would like to thank once again all our speakers, our audience, and of course the viewers around the world. And I wish you all the luck with the rest of the conference. Thank you very much.
okay.